Hello, I'm delighted to be joined by Lucas Sterop. Lucas is a partner at Lexence in the Netherlands. I've had the pleasure of knowing Lucas, I think coming up to the last 6 years, Lucas. Lucas is one of our external counsel across Europe, and he is a leader in his field. He's been highly referenced and regarded by Chambers, which is the Bible of lawyers. Lucas specializes in employment and labour law, and he's been instrumental in helping CXC and indeed our end clients navigate the WAB legislation, collective bargaining in the Netherlands. He's given us great advice on the EU Directive on platform workers. He's given amazing advice on the DBA legislation and regulations, and also the model agreement as it is known in Netherlands. He's also a really likable guy and an expert in his field, and I always enjoy our conversations, Lucas. So how are you doing, my friend? Are you keeping well?
Yes, thanks for the great introduction, Connor. It's a pleasure as always. After such a great introduction, what needs to be said more? I don't know, on my behalf. Just to give at least a short introduction, indeed, I'm a partner at the employment law section of my law firm, our law firm, Lexence, which is a larger Dutch firm that facilitates not only Dutch but also international clients, as you well know. Yeah, I've of course a particular interest in employment law, and especially also with regard to the topics that we're going to discuss today. So I'm looking very much forward to discussing this with you again.
Well, Lucas, thanks so much, and we really appreciate your time, as do our listeners, because there's changes coming, I think it's fair to say. So for the benefit of our listeners and our audience, Lucas, the DBA or model agreement regime has been in place in the Netherlands, I think, since 2017, with some variations. There's been, some of it has been enforced, some of it hasn't been enforced. There's been, I suppose, a pause. And then I was reading the Dutch press, specifically a lot of the press around employment law and legislation. And it seems to be the case that things are going to change, Lucas, in terms of the model agreement and the DBA regulations, and that the Dutch tax authorities look to be launching or about to launch some more investigations in this space. And also they look to be going to enforce some of the legislation or the previous regulations, as best as my understanding. And I appreciate Dutch isn't my first language, Lucas, so I might have picked that up wrong. But would you just, for the benefit of our audience, Lucas, give a brief overview and history of the current legislation, regulations and regime as it pertains to self-employed professionals, as it pertains to the model agreement as it's known, and also, and I appreciate this is a lot, what's going to happen in 2025 and 2026?
Yeah, sure. I think it's best to just give a really highlight of what is currently in place. I think you were first referring to the so-called model agreements. Those are provided through the tax authorities, and the idea is, if a independent contractor makes use of a model agreement, which includes several elements, the most important of which is the absence of any sense of control of the client over the work, then you would be deemed an actual or a real independent contractor, contrary to the employee. That is only for tax purposes, basically, but the underlying framework of assessment, basically, that determines whether or not you're an employee or an independent contractor, which is, of course, always the big discussion, not only in the Netherlands but throughout Europe, is largely based on case law in the Netherlands. It has been, a subject of discussions for many years, and the attempt with the model agreements was, at least for tax purposes, to provide some clarity on whether or not, in a certain relationship, the worker would be an actual independent contractor or an employee. But the introduction of this model agreements, but also the underlying case law, it just continued to be a very confusing situation. And this is also one of the reasons why, after the implementation of the DPA, the actual enforcement by the tax authorities was suspended for a couple of years now. Because of this unclarity and the potential consequences that would have for the clients and also for the workers involved. It does appear that finally the tax authorities are actually going to start enforcing. So basically looking actually into individual relationships and also, imposing penalties and such if you wrongly indicate that you are a independent contractor instead of employee. As of next year, 2025. So that is but it's more of a practical change in the field, as so to say. Similar at the same time, there have been many attempts to develop a new system in which all this unclarity is resolved, and this has now resulted in new legislative, let's say, proposals. Basically, okay, the English translation would be that it's a legislation aimed at clarifying the working relationship. That will be an interesting, let's say, proposal, and maybe we can dive in it later. But it basically aims to provide parties with basically a format or a system by which you can weigh certain elements, certain indicators, and there's like an outcome. There's an employee or independent contractor. So it aims to simplify or at least clarify and to provide tools for that discussion. Those are basically, at least in the Netherlands, I think the most important aspects of the current situation and the future situation. I do know that it's still a proposal. It's currently with the Council of State in review. So it's still uncertain whether or not in this form it will actually be adopted. But it is expected that, or there's a high chance at least that it will indeed see the finish line. So very curious to see if that will also happen.
Yes, and Lucas, sorry to interrupt, but could I ask a couple of questions, or would you prefer to continue?
Maybe you can just ask your questions, and I think that if it's not all work, I will.
Okay. Well, Lucas, thanks for that exceptionally thorough and straightforward breakdown. So, if we look at the model agreement as it stands today, and the tax authorities are going to look more closely at the true relationship between an independent contractor and the end user, Lucas, in the event that the tax authorities come knocking on the door, do they go to the independent contractor, the intermediary, or the end client, or can they go to all three? That's question number one. And then question number two, is there a sanction in terms of civil or criminal liabilities for any of the three parties in that chain?
Yeah, so actually it's a good question, but I think primarily they will go to the client. I guess the tax authorities can go to the independent contractor as well. I don't really see the intermediate. I'm not sure what the tax claim would be there. I'm not a tax advisor, but I think it's less likely. I think it's most likely that the client, so the potential employer, will be the party that the tax authorities will investigate, because that is of course also the party that is obliged to pay the taxes and the social premiums, potentially at least with respect to the salary or the wages paid. So that is where the tax authorities will come looking most likely. And in terms of penalties, and I mean, of course, if the tax authorities find that there is a employment relationship, that will mean that at least from that moment on, you have to pay wage taxes and social premiums. Then there's the question: will they backdate that claim? And secondly, or thirdly, is there a penalty involved? And I think there were. Oh, my screen. Do you still see me? Because my screen just jumped off.
Yeah, we see you, Lucas. We see you, and hear you.
I'll just continue. I think the pause in the enforcement consists of several aspects. I think they were still looking in some areas, especially some areas where there's a high level of potential fraudulent situations. But generally speaking, now when this pause will end, you can also expect to be obliged to backdate those payments. So that there will be potential significant risk if you don't follow the process correctly. If you don't pay wages and premiums where you should have, and then there is also potential penalties. But I think those are mostly meant for repeated offenses of this process.
I see. Lucas, this is why I love working with you and I love listening to you, because you always set things out in such a thorough and easy to understand way. And no disrespect to your, not your colleagues in Lexence, but legal colleagues generally, they don't always set things out so simply and clearly. So thanks for bringing clarity to this. So, Lucas, if we look briefly, if we may, at the draft legislation that you referenced in relation to how independent contractors are classified. It would sound to our British listeners a bit like IR35 in the UK. So the government, the tax authorities in the UK, essentially launched a tool, an online tool called the CEST tool, CEST for short, to help organizations and enterprises classify workers to determine and decide if they're independent or should be treated as an employee for tax purposes. Interestingly, only for tax purposes and not for employment law purposes. So in the UK, you had this dichotomy, Lucas, where you could be deemed an employee under CEST, right, under the CEST tool, but you would not have the rights of an employee, right? So you had taxation without representation, which is really interesting dichotomy in my view anyway. So I know it's only at the draft stage at the moment, Lucas, but do you think that the regime will look similar to that in Britain or the UK?
Well, and currently you can also have that situation already in the Netherlands where the tax authorities have more, let's say, thorough look at the relationship and your contractual relationships or the civil law relationship between the parties is still considered contractor relationship, while the tax authorities do force the parties to pay wages. So it is that diversion or that difference is also possible in the Netherlands. I think
Yes.
with the new legislation proposal, which is not specifically aimed at tax purposes, but just to provide a new legislative system wherein also the civil relationship is should be more easily clarified. I think in the future, I think it's potentially still possible because it's just different routes. What on the one side you have a discussion with tax authorities, and the other side you have a discussion in front of a court by determining whether or not the contractual relationship is employment or independent contractor status. I think in the future that might still be possible, but the idea of this system is to introduce a uniform framework in which this assessment is made. So I think the idea is that it provides more clarity in both scenarios.
Yeah, would it be fair to say, Lucas, that you welcome the draft legislation because it brings what could be considered? No, maybe not.
Yeah, it was always been the intention, as always. I think the intentional is commendable. So
yes.
Especially case law, you see that a lot of insecurity or uncertainty arises from the complex holistic assessment that then is applied, and that each court, each judge could have a different opinion. There is a lot of uncertainty there, so the idea is to remove that uncertainty and also to get rid of cases where workers are deemed contractors, they lose rights, and in those cases where that should clearly not be the case, I think such a system could be helpful to them.
Yes.
But on the other hand, I think maybe it's also helpful if I shortly briefly dive into the components of the assessment. But what that shows is that it is derived basically from what already existed in case law. So the same elements are introduced to a new system in a certain mechanism, And of course, the benefit of that is you have a certain process, you have a certain mechanism that you can apply. But the downside is that you still have the same discussions on the elements that are included. I think it will be helpful just to briefly dive into what
Yes,
it will look like.
please.
So simply said, there is the system aims to provide you with a set number of indicators, which one indicator indicates how there is an employee. The other indicator indicates it's an independent contractor. And
Okay.
if you add or weigh both sets of indicators, then there should be an outcome. And clearly, hopefully, it's an employee or it's an independent contractor. So I will give you. It's more easy for me. I'm good, but not that good that I know them all by heart. So there's a indication for pointing to working as an employee are the power to give directions or the authority to give instruction and directions as regards the work, and the possibility of control intervention. So basically saying you're doing this wrong, you should do it differently, you should do it that way.
Yeah.
The work is carried out within the organizational framework of the organization. So the employees working in the same building, using the same equipment, under the same employment conditions, or basically the same work. Another aspect is the work is structural in nature. So it's not incidental work that is done by an outsider, but actually work that forms part of the whole of the business of the company. Doesn't need to be the core business, but also supportive business. For example, the back office is considered structural work. Another indicator is the work is carried out side by side with other employees. So if those indicators are there, then that clearly points to a work relationship. Okay. Then there are indicators of being an independent contractor. These are the financial risks and results lie with the worker. The worker is himself responsible for tools, aids, and materials. And the worker possesses specific training, knowledge, or skills which are not structurally present in the organization. The worker acts independently, so without that supervision and control. And then another indicator is a short duration of the assignment or limited number of working hours per week. So if you check all these indicators and you balance them out, and hopefully at least that is the idea behind the proposal, one of the two will stick out, and the conclusion is it's either an employee or it's a independent contractor. So of course, a lot of discussion can still be had about how you weigh the individual indicators, and it might not be as clear from this list that I just told you whether or not one of those indicators is actually really present. So there's a lot of discussion still possible there. Yes. But then we're not there yet, because if both the indicators are employee, independent contractor are balanced, then there is only then you will start to look at another aspect of the relationship, and that is the characteristics that are indicating overall entrepreneurship. So what you can do then is not just look at legal relationship between the client and the worker, but also at the worker himself. How is he manifesting himself in society as an entrepreneur?
Yes.
There are also indicators for that purpose. The worker has several clients, spends time on money, getting reputation, and has a business investment, etc. This is not a limited list. And then, so if that balance between worker and independent contractor is there, and you look at this to see is the worker then manifests himself in society, and hopefully that will lead to a shift in the balance. Yeah. So while the idea is good, I think it's not that different from what we already see in case law. It's basically a sort of holistic approach, and still a lot of discussion can be had on the individual element. So although I think the intention is good, I really question whether or not it will bring the change that the legislator is looking for. But this is something that we'll have to see how does it work out in case law. If it will be very strictly applied, and if there are further developments and experience in how this will be actually handled in the future.
Yeah, Lucas,
I hope that was
yeah,
clear.
Lucas, abundantly clear, and I can't help but think of the huge similarities between what you've just outlined and UK legislation on our IR35. It's almost completely the same, and just from my experience and our experience, it's been quite problematic for large enterprises to cope with this change and this legislation change because they did not have the systems, processes, and change management and operational readiness, or indeed understanding, to fully implement this legislation. And interestingly, Lucas, for some of our international listeners, and maybe for you too, is that the UK tax authority's own tool was not fit for purpose. So when it went to when people went to appeal it, a decision, the courts actually overturned the use of the CES tool and said it was not fit for purpose. So I think you're right to welcome it, but also right to be worried about the unintended consequences of legislation, such as this. I had a question, Lucas. In the draft legislation, is there an appeal process built into it? So let's say, for example, a independent contractor is deemed an employee and she or he says, whoa, hang on, I'm taking the financial risk. I'm an entrepreneur. I've got my own BV structured company. I've got a business bank account. I've been in business for 14 years. I've got multiple income streams. I want to appeal this. Is there an appeal mechanism built into the process?
Yes, because I mean, it's just like it's more of like a handout mechanism. So I also forget to mention, actually, if there's a minimum wage, if you are earning as an independent contractor less than 33, well, currently 33 euros per hour, then then the presumption kicks in that it's an actual employment relationship. So that's also an important element to take, especially with relatively low paid work. I think that that's will lead to a lot of cases where that presumption kicks in. But so once, for example, the employee or other party believe that this weighing of circumstances will lead to the conclusion that an independent contractor is not there as a discussion on that, it will still have to be brought for a court. So the board that seeks to enforce the outcome of assessment will still have to go to court. There is no, it doesn't have any immediate effect on the legal relationship. So that's why, I mean, it's a good idea. It doesn't give that certainty yet, because still in the end, the battle or the discussion will be have to fought out in front of the courts, who have also fed basically all the indicators that are already included here. The question is, what will actually be different in the future? That does, I mean, of course, if there's like a bunch of case law, a bunch of judgments are all the same, and everybody is on, in line on what this will mean in individual cases, then it will be very helpful. But I expect that there will be again a variety of different verdicts of case law and individual cases, which will then lead to a situation where there is still not the clarity that you would have hoped there to be.
Yeah, I think that's
still work for
well, yeah. That's good news, Lucas. But I think some of the legislation like this can actually really strangle the labor market flexibility, right? And I don't think that's always the idea behind it, of course. So, Lucas, I'd just like to touch very briefly on the EU directive on platform workers. I know we've discussed this a number of times over the last 4 years, but it's now received its assent in the EU Parliament and the European Union, and it's now been sent, I suppose, to the EU member countries or states to transpose or bring into effect that directive. Has the Netherlands started the draft process for that, Lucas?
No, I don't think so. I mean, not that I'm aware of.
Yes.
And it's, I mean, I think discussed it before on a number of occasions, but it has been very much tuned down. And the initial idea was that there would be a uniform a directive that would, provide that clarity for platform workers, of course. But it is now really left to the individual national members of the EU to implement in the way they see fit. So there's, in that sense, it's become a very weak proposal.
Yes.
Which in essence I also don't think is too bad, because especially the European Parliament proposal, which was very, very, very strict and now very difficult, I guess, for platforms to work with. It would have created a lot of problems. But now there's a big question mark, because especially the part that will determine, whether or not a platform worker is a worker or independent contractor. It's just entirely up to the individual members of the EU. So a big question there. That it will depend on each country how to deal with that. In the Netherlands, I think we can expect a similar approach as the one we just discussed. I mean, it would not make a lot of sense if there would be a total different approach. So I think a similar weighting of criteria process will be introduced in the Netherlands. Of course, specifically zooming in on the intricacies or the complications you have with platforms where algorithms are involved in supervision and management of employees or workers. But there's not much clarity yet on what that will look like.
Yeah,
and it's also very, very brief, of course, since a couple of months since this was established.
Yeah, it's quite interesting, Lucas. Though to your point, what was meant to be a uniform approach across all the European Union is now a fragmented approach, and what was meant to give workers certainty engaged by talent marketplaces or talent platforms, whether they're in Netherlands or Sweden or Ireland or Spain, and engaged by those platforms, the certainty's gone, right? And we could get back to a position whereby, let's say, Ireland has a very strong regulatory approach for this, but Netherlands might have a lighter touch, or the model that you've just described. So what was meant to give certainty has now created uncertainty and additional complexity, right? If you want to move across a border, for example, or work in a platform, let's say, that's headquartered in Ireland, but the work is conducted in Netherlands, right? So it's actually become more complex in a way, in my view. Would you agree with that, Luca?
Yeah, no, I do agree. I mean, basically, the situation, like whereby there is. I mean, it will depend on which country you're working in, and the local court's interpretation of European legislation and the new legislation that will be put in place nationally. I think there will likely be big differences between the country. So one of the initial ideas of the proposal to create that uniform situation with more protection for the workers involved, it will not, at least not entirely, be achieved through this new form of the directive. Of course, there are some other changes regarding privacy and transparency, etc. That will get to the finish line. But I think the most important part of this whole proposal, or one of the most important parts, was specifically creating that uniform and clear situation with respect to platform work.
Yes.
And I think that will not be achieved now.
No, I agree, and I actually think that is the great sadness about this, Lucas, particularly for platform workers that are at the bottom of the economic pyramid, those that are in the most precarious positions and doing the cheapest work, if that makes sense, which is a really bad way to describe it. But Lucas, I just wanted to say thank you very much for your time. Thanks so much for taking the time to explain the change in enforcement regime in the Netherlands, and also for what's coming down the track. And I always love our conversations, Lucas. You really bring much needed simplicity and clarity to legal matters, and just for the benefit of our listeners, what Lucas has said is not advice. It's not legal advice. He's merely giving his observations as a lawyer on the current regime and what's likely to happen. So please do not take this as legal advice. If you want legal advice, though, please do not hesitate to reach out to Lucas. Lucas, where is the best place for our listeners to find you and to contact you about any legal matters, Netherlands or international?
Yes, I think, well, first of all, thank you very much for this time, Connor. Also, I'm very happy to speak to you on these matters again. I think if you want to contact me with questions about this, you can best contact me at my email address, l.stuurop@lexence.com. But you can also find me if you Google me, of course, through our company's website. Yeah, that's it. Good. Thanks a lot, Connor.